Hi, I'm Sam Silverman. It's October of 2012, and I wanted to discuss the steps that have to be gone through when trying to prove someone is disabled pursuant to Social Security disability law. There's a 5-step sequential process that is used, and though I don't expect you to become a Social Security disability attorney based on a short video, I think sometimes when you can see the forest through the trees and understand what you have to prove, it makes it helpful to you to be able to kind of digest what is going to happen when a judge tries to evaluate your case. Step 1 involves proving that you don't make too much money to get Social Security disability benefits, meaning that you are not earning at a substantial gainful employment level. To make a long story short, the level currently is a little over $1,000 a month before taxes are taken out. So if you go apply, they're going to look into whether you're earning too much before they'll do a medical evaluation. The next step is to prove that you have a severe impairment or a combination of problems that are equivalent to a severe impairment. Typically that's not very hard to do. Most people that apply have some severe medical condition that causes work-related issues and limitations, and that will get you to step 3. Step 3 involves a review of whether your condition meets or equals a medical listing of impairments in the Social Security regulations. Now, those listings look somewhat like a phone book. They have literally hundreds of different possible ways that you can prove you're disabled. Many people will ultimately have a condition that meets or equals a listing, but by my experience, I've learned that normally we have to move on to steps 4 and 5 to prove someone is disabled, though listings can apply. They don't basically result in you not getting your benefits if you don't specifically meet a listing or regulation that applies to a physical or mental disorder. Now, step 4 involves proving that you cannot do your past work. Social Security will look at the past 15 years of work history to determine your past relevant work and make a decision regarding whether you can do that work. Once we get past step 4, step 5 involves proving that you cannot do any past work, and then in step 5, any other work that is in Michigan's economy or your state's economy if you're in a different state that would basically involve something that you would be expected to do at your age with your educational background and etc. But to make a long story short there, I want to point out that there are what are called grid rules that can apply to your case. If you're over 50 and hypothetically have a history of doing work on your feet that's factory in nature or labor intensive or unskilled, you can often be found disabled by being limited to a sit-down job. If you're over 55, you can often be disabled or found disabled by being limited to a light job, meaning lifting less than 20 pounds occasionally and 10 more frequently. And the same rules apply, and vocational experts have to testify about whether you can be transferred easily to a skilled job that is easier than the one you did that you can't do anymore. But ultimately, those are the steps that we go through to prove that someone is disabled, and we do everything we can at my office to gather information and make that happen. Of course, you should feel free to contact me at my office and we can run through some of these steps in your case and see what may apply to you. Thank you.